Welcome to Vera Voices. I'm Bruce Frederick, co-author with Don Steeman of a Vera Institute of Justice study that examines prosecutorial decision-making. I'm here with Anthony Thompson, professor of clinical law at New York University. Professor, thank you for joining us today. The prosecutors in our study distinguished between two basic questions that they have to answer. Can I prove the case? And should I prove the case? In their answer to that first question, they focus almost entirely on the strength of the evidence. In examining that second question, should I prove the case, they look at a variety of other factors. What factors besides strength of the evidence, seriousness of the offense, and other characteristics of the case itself are legitimate for prosecutors to consider when they're answering that second question? Should I prove the case?
We've seen legislation over the last 20 years that has significantly increased the types of collateral consequences associated with a criminal conviction. So one of the things that I think if prosecutors are not sensitive to, and I think a growing number of prosecutors are indeed sensitive to this, but what are the collateral consequences if I prosecute this? For example, if I prosecute this teenager in adult court, am I essentially or effectively evicting his family from public housing? Am I making this parent unemployable because their occupational license will no longer be available to them in this state with the criminal conviction? At least at the initial stage of plea bargaining and charging, I think that those are considerations that prosecutors can and should take into account, but it requires a certain philosophical shift in certain offices. So thinking about what are the norms that we want to put forth that we would consider in a plea bargain for an office is something that needs to be examined pretty closely. One of the things that I'm concerned with when we begin to think about how to process evidence and whether or not we can prove the case, and this is separate and distinct from the should we prove the case, is the conversation about what are the incentives. Have we traditionally prosecuted this type of crime? Should we be concerned, and are we concerned about criminal justice resources? Are there enough investigators in our office to go after this type of misdemeanor versus this type of misdemeanor? Because one of the things that I've learned in my work over the years is that if we can teach it correctly to young lawyers, that information is quite portable depending on, irrespective of what team you're on and what type of crime. If I have a good pair of glasses, however I see the evidence, it works well. And so one of the things I'm concerned about when I was reading the study is what were the types of information given before we begin to process. I think one of the things that struck me was this notion of if there's a gun is a gun. Well, that's fine if you have hard physical evidence, but much of assembling a prosecution is interpreting evidence and making inferences. And so prosecutors, particularly young prosecutors, benefit, I think, from good supervision about how that mechanism will work.
What about external considerations, external conditions, factors such as prosecutors' relationships with other organizations and their relationships with police and with defense bar and with judges?
So one of the things I'm very interested in is how do communities perceive a prosecutor's office? Do they perceive it as a service provided in our community, or do they perceive it as somebody who comes in and uses witnesses and uses victims to make their case and moves on? So I think one of the things that we can get better in on the front end is having prosecutors in other than election years spending time in communities. So let me tell you one of the effects of that. When you talk to me about what other organizational relationships should be considered, the broader those relationships, the more considerations you're going to take into account. And I think what it does is those prosecutors who are very good at that, and there are quite a few in this country, have really built good relationships in the community. It serves as a check and an information feedback loop for them on the job that they're doing. Secondly, I think that it makes younger prosecutors who have to get out of the office and spend time in communities more sensitive to issues that they should be sensitive of when they're wielding this incredibly important power of prosecutorial discretion.
What implications, if any, do you see for the findings of this study for the training and the orientation of potential prosecutors and defense attorneys?
That's a great question, Bruce. I think there are a couple, right? First, I think that one of the most difficult things for young lawyers, be they prosecutors, defenders, is to develop judgment, what I call professional judgment. On the prosecutor side, it really is how should I make decisions with this huge power of prosecutorial discretion. So I think one of the real key pieces of this study is that prosecutors' offices nationally should begin to engage young lawyers in what I call reflective lawyering. Engage in uses of discretion in which you will go back and handicap those with somebody more senior. It doesn't have to be a supervisor. And say, this is what my thought process was. This is what I was thinking when I made the decision to offer this negotiated plea or to try this case. But to give them an opportunity in a safe setting to begin to learn how to exercise discretion. I think the study was pretty clear that as you get more senior in the office, those are really much easier decisions or clearer-cut decisions. And as I said earlier, my belief is if we teach this to young lawyers, they carry it with them throughout their career. So I think the study really did a good job of underscoring the need to develop those skills. Finally, particularly around innovation, we've got to think about ways to get young prosecutors to come in and challenge cultural norms. Very hard to do in any office, whether it is a corporate law firm, a public defender's office, or the best prosecutor's office in the country. The notion that new prosecutors come in with new ideas is virtually unheard of. One of the examples that I've seen that is interesting to me, and I'd like to study a little bit, is that I've seen a jurisdiction in which a prosecutor is giving misdemeanor deputies cold cases, cold homicide cases, and saying these cases have sat dormant, take a look at them, spend some time in them, and give us some new ideas. It's a phenomenally innovative way to teach young lawyers to be creative. And so I think when you can do it without live ammo, if you will, it's a safe space for young lawyers to learn how to do their craft. And so I think that the study is really a great springboard to begin thinking differently about how we have lawyers approach this task.
Well, thank you very much for your insights and coming to talk with us today.
Thank you.